What if the people who stormed the Capitol not only walked free, but sent you the bill for it? Yeah, let's talk about the Proud Boys' pardon payday. So you already know a presidential pardon can wipe out a federal conviction off the books, but probably no one warned you it could flip into a 9-figure jackpot. So tonight, I'm going to crack open the story of 5 freshly pardoned Proud Boys who've taken their freedom and tried to parlay it into a $100 million lawsuit against the Justice Department, an action that, of course, could hit your wallet as a taxpayer, bend some of that rule of law, and change the way future presidents dangle clemency like a Black Friday doorbuster. First, the essential paper trail. On January 20th of 2025, the very morning he retook that oath of office, President Trump sprayed the political equivalent of legal Febreze across 1,600 January 6 defendants. One executive order and the felony funk vanished. Among the biggest beneficiaries, the Proud Boys chairman Enrique Tarrio, and 4 lieutenants, men once hammered with seditious conspiracy sentences reaching up to 22 years. Now, these weren't just mere commutations for the most part. In most cases, they were full-blown pardons, wiping away guilt, restoring gun rights, and clearing a legal runway for civil suits. And within weeks, Tarrio and company marched into federal court filing Tarrio et al. Versus United States. Their complaint reads like a legal shopping list: malicious prosecution, due process violations, selective enforcement, the whole kitchen sink. Their price tag, $100 million of taxpayer cash to compensate for time served, reputation ruin, and what they brand as a politically motivated lawfare. Now, if you're wondering whether someone can be punished, pardoned, and then profit, stick with me. We're going to stress test some of that constitutional plumbing. The country's response could light a hydro dam. Right-leaning commentators have hailed the lawsuit as a righteous counterpunch to that weaponized DOJ, parading families' photos across morning shows, repeating phrases like political prisoners, and invoking the founders' warning about overbroad treason statutes. Meanwhile, the left, predictable as always on its outlets, has labeled the move as an insult to injury, accusing the pardons of whitewashing insurrection and framing the payout demand as moral vandalism, comparing it to a getaway driver suing for whiplash. Society erupted so fiercely that within 48 hours, the hashtag Pardon Payday cracked 200,000 mentions and rocketed in national trends. Comment threads devolved into trench warfare, with money printer memes clashing against gallows pole emojis. If outrage generated BTUs, social media alone could heat Alaska right now. But let's talk a little bit about that law. Article 2, Section 2 of the Constitution grants the pardon power to the president to issue pardons and commutations. And once that ink dries, federal guilt can evaporate. But how about liability in general? Well, that's a slightly different beast. A pardon does end the punishment, but it also leaves intact government shields of sovereign immunity and prosecutorial immunity. To collect cash, plaintiffs must crawl through the Federal Tort Claims Act or try a very rare Bivens pathway. The Proud Boys complaint, of course, tries both. Under the Federal Tort Claim Act, they allege prosecutors ignored exculpatory evidence, trampling departmental policy. Under Bivens, which is a U.S. Supreme Court case as well, they accused FBI agents of viewpoint discrimination, claiming the Bureau targeted them for political speech. Their odds for either cause of action? Pretty slim. The Supreme Court has been swatting away any new Bivens cause of action since they came up with the concept like a summertime mosquito. Still, the tactical brilliance here isn't necessarily about winning a lawsuit. It could be about forcing discovery, hauling prosecutors and agents under oath while cable skyrons spin. Some pundits have trumpeted that a pardon erases self-incrimination, blocking a governmental defense. Well, that isn't quite right. The Fifth Amendment does bar a criminal bite, but civil liability is, of course, a fresh plate. Think similar to O.J. Simpson. Acquitted criminally, but civil liability could still be imposed. Here, the roles, however, are flipped. The government will be defending the ex-felons, effectively the prosecutor. If their claims wriggles past dismissal, the DOJ could face depositions, document hunts, and expert bills that could burn through $10 million before we ever see a trial. A nuisance settlement at 20 cents on the dollar still lands in 8-figure territory. Multiply that by 1,600 pardoned rioters, and taxpayers could be flirting with a billion-dollar boondoggle. History does offer some cautionary tales around this domain. Iran-Contra pardons once blocked civil suits because victims lacked waiver language. Trump's blanket order added no such carve-outs. Critics say he could have cracked open a vault door nobody realized existed until now. Can Congress slam it shut? Conservatives do cherish limited government, and no one, right or left, likes paying someone else's legal tab. Capitol Hill Republicans have floated an amendment to 28 U.S.C. 2680, which could shield prosecutors from suits from this kind of cause of action. Democrats have countered with a no pay for pardon perps bill, stronger language that would bar federal payouts when violence against police is involved. Neither proposal currently commands any votes to pass, but both serve as medium-term fundraising ammo. Beyond budget considerations, we need to consider the security fallout. Police unions have warned that a payout here hikes the street value of political violence. If you storm, you could get pardoned, sue, and retire. Free speech absolutists insist the lawsuit tests whether ideology can be criminalized. Victim advocates, for their part, dread seeing officers battered on the January 6th watch, their assailants cashing in government checks larger than a lifetime pension. Legal victories, of course, always reset norms. One well-publicized win could inspire crowdfunding blitzes for the next mob chasing a pardon ticket. But let's pump the brakes on the partisan whiplash and examine a little bit more of the doctrine. Textualists, of course, remind us that the pardon power is absolute. Blame the framers, not Trump. If voters dislike the pardon use, they must either amend the Constitution or revise civil statute. Channeling Federalist number 74, Alexander Hamilton described mercy as an act of grace, never a springboard to shakedowns, and courts may honor that principle by tossing suits that weaponize pardons for profits. Structuralists, of course, worry. If civil courts relitigate riots, the executive grants mercy, the judiciary reopens wounds, and Congress foots the bill, separation of powers could take collateral damage. The conservative sweet spot appears defending broad clemency, yet tightening civil loopholes, so mercy doesn't morph into a money ball. So, as for this particular lawsuit, where does this all go? Well, I see a couple different scenarios that seem likely. Scenario A judge cites sovereign immunity, boots the case, and plans fundraise off deep state bias. Scenario B, a discovery circus. Depositions air alleged FBI missteps, DOJ writes nuisance checks, each plaintiff pockets some sort of settlement. As for scenario C, some sort of court trial. Moral blame potentially recognized, but damages perhaps denied. Appeals ensue, and the Supreme Court might have to once again revisit Bivens, clipping future suits nationwide. Whatever door opens here, of course, the ripples will extend far beyond January 6th and in other domains, such as potentially those who torch in the name of environmental protests, abortion clinic blockaders, cyber attackers, potentially anyone eyeing that pardon coupon. So, what does this all mean for you? Unlike state tort caps, the Federal Tort Claim Act has no caps. The federal tax bill is America's backstop. Clemency, designed to temper justice, now could risk fueling jackpot justice, eroding confidence faster than inflation erodes savings. Politically, the right spotlights prosecutorial overreach, the left highlighting pardon abuse. Both bases fundraising with polarization deepening. Remember that opening question? What the people who stormed the Capitol not only walked free, but sent you the bill? Well, that question is no longer hypothetical. It's filed as docket number 251734. If you believe the framers nailed pardon power but never intended civil payouts, make sure to drop that phrase, mercy does not equal money, in the comment section. I'll spotlight the sharpest constitutional fix in the next episode. Until next time, I've been Uncivil Law, and remember to keep it uncivil out there.